This module is on surrogacy rights and women, the rights of the surrogate. The content writer was Manasi Kumar, Assistant Professor at Jindal Global Law School. By the end of this module, you will have a good understanding of what surrogacy is and its different forms, different laws that apply to the surrogacy process, and how they apply to the different parties. The costs, such as expenses and remuneration, that the surrogate may benefit from. The module will also include some of the most pertinent concerns regarding the regulation of surrogacy and areas where law may be able to play a greater role in regulating it in the future. Surrogacy is the practice where a woman agrees to bear a child in her uterus for another person. This procedure is legal in India. The woman who bears the fetus is known as the surrogate. The people for whom the fetus is carried and to whom the child is handed over upon delivery to are known as the intended or commissioning parents. Sometimes a single person is the intended parent. For ease of reference, in this module the term intended parents will be used to denote both a commissioning couple and a commissioning individual. The need for surrogacy may arise for two reasons: medical and non-medical. The medical need for surrogacy arises when the intended parents are unable to conceive. This may be because of infertility, or it may be because the couple are in a same-sex or homosexual relationship. The non-medical reason arises when heterosexual intended parents decide, for their own personal reasons, that despite being able to physically conceive, they do not want to undergo pregnancy. Similarly, a surrogate may be impregnated in two ways: sexual and non-sexual. In the sexual process, the intended father will engage in intercourse with the surrogate to conceive. However, the surrogate will, upon delivery, hand the baby to the intended parents. The much more common procedure today is the non-sexual process. This process involves the impregnation of the surrogate through in vitro fertilization, or IVF. IVF is the procedure whereby an ovum is fertilized by sperm outside the human body, and the fertilized ovum or embryo is then implanted into the surrogate's uterus through a process called embryo transfer. The ovum that is fertilized may belong to the surrogate, the intended mother, or another woman known as the egg donor. Similarly, either the sperm of the intended father or a donor may be used. IVF is a complex process. As mentioned above, the ovum and sperm may be donated. Sperm donation is a rather simple procedure whereby the male manually stimulates himself to ejaculate in a clinic. His semen is collected and stored for further use. Egg donation, however, is a much more complicated procedure as it requires many hormonal injections into the woman's body to stimulate the growth of eggs. Once the eggs are ready, a medical professional extracts them through the female body, either through a needle or through a laparoscope. These eggs are then fertilized with the male donor's sperm in a test tube or a petri dish. This forms embryos. These embryos are then transferred to the woman's uterus. Since the fertilization may happen in a test tube, in popular media, the children produced by this process are commonly referred to as test tube babies. This IVF procedure is used by many women who are unable to conceive to help them attain a pregnancy. IVF technology is used on surrogates as well, in the case of non-sexual surrogacy. Different forms of surrogacy exist. There are two main types of surrogacy: traditional surrogacy and gestational surrogacy. Traditional surrogacy is where the surrogate is genetically related to the embryo. For example, the surrogate's own egg is used to create the embryo. Gestational surrogacy is where the surrogate is not genetically related to the embryo, so another woman's ovum is used to create the embryo. Both types of surrogacy may be further classified based upon whether the surrogate is carrying the fetus for remuneration or not. When a surrogate is being paid for her services, the arrangement is called commercial surrogacy. When a surrogate is not receiving remuneration, the arrangement is called altruistic surrogacy. Altruistic surrogates usually still have their medical expenses related to the pregnancy covered by the intended parents. In every surrogacy procedure, there is at least one woman in a surrogacy arrangement, the surrogate, or the woman who will have the pregnancy. There may, however, be as many as 3 women. If the intended parents are a homosexual couple, the intended parents, both male, will need an egg donor and surrogate who may or may not be the same person. In a heterosexual couple, there is the intended mother, and if the eggs are extracted from another woman, there is the egg donor. And if the surrogate is unrelated to the donated eggs, she will be the 3rd female party. If the parents are a lesbian couple, they may choose to use one of their own eggs or to use a third party's, and therefore up to 4 women may be involved if another woman, also genetically unrelated to the fetus, is the surrogate. There are therefore various issues with regard to women's rights. For the purposes of this paper, we shall only address the rights of the surrogate. A surrogacy arrangement is governed by contract law. In India, in the absence of other regulation, the Indian Contract Act of 1872 becomes the governing law. The Ministry of Health and Child Welfare, in conjunction with the Indian Council for Medical Research, has also created a draft bill governing alternative reproduction technologies, including IVF and surrogacy. The Alternative Reproduction Technologies Regulation Bill of 2010, otherwise known as the ART Bill, the Ministry has also drafted supporting rules which lay out the mandated form of most of the contracts involved in this arrangement. The Alternative Reproduction Technologies Regulations Rules, or ART Rules. Every commercial surrogate enters into a contract with the intended parents, whether written or oral, where she agrees to bear the fetus to term and the intended parents agree to pay her in return. Under the Indian Contract Act, any person who enters into a contract must do so with their free consent. Free consent is defined as consent given without coercion, duress, fraud, misrepresentation, or mistake. There is a requirement for all people entering into contracts, but in surrogacy it becomes an especially important issue for the surrogate. The decision to become a surrogate is often an economic one. The surrogate is in need of money. In India, this is especially true. Due to the conservative views in society and a lack of awareness of the surrogacy procedure, people tend to equate surrogacy with prostitution. Therefore, surrogates tend to be in desperate need of money before they consider going against social norms. Often, the Alternative Reproduction Technology Clinic is less than forthcoming to the surrogate about the terms of the contract, the nature of the risks involved with the procedure, and the money she will actually make as a result. One may also worry about whether the surrogate's husband has pressurized the surrogate into entering into the agreement. As a result of the surrogate's vulnerability caused by her financial difficulties, her position in the family, and her lack of information, there is concern that her decision to become a surrogate in certain instances may not be the result of free consent. Unfortunately, the financial vulnerability of the surrogate also means that she is unlikely to be able to procure adequate legal representation in the case of any dispute. Therefore, many challenges to the surrogacy agreement which may exist are likely to go uninvestigated and unquestioned. As mentioned above, with up to 3 women involved, including the surrogate, the intended mother, and the egg donor, there may be questions asking who is the real mother. Is it the woman who bears a biological relationship to the child? Or the woman who pays for the child to be brought into the world? Or is it the woman who gestates and delivers the child? The issue has seen a lot of debate and confusion since the inception of surrogacy. The earliest example of this question being raised was in the Supreme Court of New Jersey in the United States in 1988. Mary Beth Whitehead had entered into a surrogacy agreement with the intended parents, William and Elizabeth Stern. Whitehead was the biological mother because her ovum was used, and William Stern was both the biological and the intended father. The surrogacy agreement stated that Whitehead relinquished all parental rights to the child upon delivery in favor of Elizabeth Stern. Upon delivering the baby, Whitehead and her husband found themselves unwilling to part with the child and absconded. The police finally apprehended Whitehead and baby M, a pseudonym used to protect the child's identity, who was delivered to the intended parents. In the custody battle that went to court, the Supreme Court of New Jersey ruled that the surrogacy contract was unenforceable because a biological mother could never relinquish her rights to her child before the child was born. The court then determined that between the biological mother, Whitehead, and the biological and intended father, Sperm, the latter was the better parent, keeping in mind the best interests of the child, and the court awarded custody to him. In India, as of June 2015, there were no limits placed on the kinds of surrogacy that may happen, altruistic or commercial, traditional or gestational. However, in the ART bill, the ministry proposed to only allow gestational surrogacy with the egg of someone unrelated to the surrogate. This would eliminate concerns about the surrogate having parental rights due to a biological relationship. Here, however, another concern arises. May it be deemed that just because a surrogate is not genetically related to the fetus, she is automatically not the mother, despite bearing the child? In Germany, for example, where surrogacy is illegal, the surrogate and her husband are deemed to be the parents of the child. On the other hand, the genetic mother may also be considered the mother. The ART bill proposed to address this issue by providing that only the intended or commissioning mother, if any, will be listed as the mother of the child. The issue, therefore, remains open for consideration from women's rights perspectives. Does a woman's biological function of gestating the fetus amount to no more than a service? Or does bearing the fetus form an essential part of motherhood, which requires a recognition that the surrogate has some form of parental rights? The issue of bodily autonomy over one's body is also a matter of fundamental rights. A woman must have the right to control her reproductive functions and make decisions freely regarding her own body. In a surrogacy arrangement, the surrogate's control over her own body is limited because she is carrying another couple's child. From a rights perspective, there are several questions left unanswered and several unethical practices left unchallenged. During the process of creating the embryos externally, doctors generally fertilize several eggs with the desired sperm. Thereafter, several of these embryos are transferred to the surrogate's uterus during the embryo transfer. This is a common practice in order to maximize the chances of a successful pregnancy. The flip side is that there is a risk of multiple pregnancy. In such an instance, doctors perform a process known as fetal reduction. In other words, they abort the extra pregnancies to achieve the desired number for the intended parents. Occasionally, a doctor may discover that the fetus is developing in a manner that makes it very likely that the child born will have disabilities. In such an instance, the intended parents may decide to terminate the pregnancy. The surrogate's rights here are left uncertain from a legal and moral perspective. There is a danger of abortion, including the practice of fetal reduction being carried out without the surrogate's consent. This is a violation not only of her fundamental rights, but also of the Medical Termination of Pregnancy Act. Under the Medical Termination of Pregnancy Act, a medical professional may only perform an abortion on a pregnant woman in limited circumstances, and always within the woman's consent. Despite this, there are occasions when fetal reduction is done without prior consent. Moreover, whilst the Medical Termination of Pregnancy Act recognizes that an unwanted child may cause great anguish to a pregnant woman, in surrogacy, the measure of whether a child is wanted is not by determining whether the surrogate wants the child, but whether the intended couple want the child. What would happen if, for example, the surrogate does not want to abort a child for being disabled, but the intended parents do? What if the surrogate wants to abort a child for being disabled, but the intended parents do not? Whose mental anguish should be measured? These are very difficult questions with no clear answers currently available under Indian law. On the one hand, the intended parents have an interest in the child that they hope to raise till maturity. On the other hand, the surrogate is the one whose body is being used to bring the child into the world. Regardless, as the Medical Termination of Pregnancy Act is currently framed, anything less than giving the surrogate complete autonomy over the decision is illegal. Further, the Indian Penal Code criminalises the deliberate causing of miscarriage in Section 312, where it states, "Whoever voluntarily causes a woman with child to miscarry shall, if such miscarriage be not caused in good faith for the purpose of saving the life of the woman, be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both." How this applies to fetal reduction has not yet been considered by the ART bill. Usually, surrogacy agreements have a provision that compels the surrogate not to engage in any act that may harm the fetus. The 2010 draft ART bill contains a similar provision that will become law if the bill is passed. Section 34, subclause 23 states, "Any woman agreeing to act as a surrogate shall be duty-bound not to engage in any act that would harm the fetus during pregnancy and the child after birth, until the time the child is handed over to the designated person or persons." It is unclear precisely what these terms mean when they say that the surrogate cannot engage in any act that would harm the fetus during pregnancy. For example, smoking or drinking during pregnancy may harm the fetus. There is, however, no accepted medical evidence that declares that having sexual intercourse whilst pregnant will harm the fetus. Despite this, several ART clinics require the surrogate to abstain from intercourse during pregnancy. Moreover, several ART clinics also closely monitor the surrogate's diet and food, despite there being no medical evidence between eating street food and a harm in fetal development. Today, the control that is exercised over the surrogate's body in India reaches almost absurd heights. The surrogate is left with no agency, no control over her body, and her life is heavily restricted. Balancing the surrogate's civil rights with the interests of the intended parents in ensuring the surrogate is taking reasonable care of the fetus is a debate that the drafters of the ART bill have completely overlooked. A fundamental aspect of having and exercising autonomy over one's body is to receive full disclosure of all material details of the medical procedures one is undergoing. Currently, the disclosures given to the surrogate are very minimal and completely inadequate. The ART Bill 2010 attempted to address this issue by requiring the ART clinic to provide all material medical disclosures to the surrogate. However, the only disclosures the mandatory contract provided in the ART rules provides address the process of embryo transfer and the fact that the sperm and ova used to fertilize the embryo have been tested for diseases, but that there is still a small chance that they may have HIV. There is no mention of the hormonal therapy the surrogate must undergo to prepare for embryo transfer, the number of embryos which will be transferred, the risk of a multiple pregnancy, the risk of fetal reduction, the risk of the child being disabled, or the risk of abortion being requested by the intended parents, and the risks associated with a caesarean birth, which is the preferred mode of delivery by ART clinics. These are all very important issues of surrogacy, which the surrogate has the right to know. Compensation and remuneration are also important, and often motivating issues for the surrogate. Although surrogacy may be altruistic in nature, i.e., in return for no remuneration, in commercial surrogacy, where the surrogate contracts for payment in return for her services, the surrogate has a contractual right to payment. The way the payments are structured involves a fundamental question about whether the surrogate is being taken advantage of, perhaps even exploited, or whether she is receiving the amount she contracted for in a fair manner. Currently, most contracts in India and abroad provide that the surrogate will be paid the majority of the payment upon actual delivery of a baby. In this event, if there is a termination of the pregnancy due to a fetal medical issue, or if there is a miscarriage through no fault of the surrogate, she does not receive that payment because she has not been able to deliver a baby. The arrangement has caused some to criticize commercial surrogacy arrangements as baby selling. This raises the question, is the surrogate being paid for the baby or for her gestational services? There is a compelling argument that the intended parents cannot pay for the baby as that would amount to human trafficking, i.e., paying for a human being, which is illegal. Those in favour of this arrangement argue that the surrogate is being paid for the act of handing the baby over to ensure her performance, and that withholding the amount is important to ensure that the surrogate does not try to withhold the baby for more money. While withholding some money may be important, in the 2010 ART rules, the amount payable upon handing over the baby is 75% of the entire compensation package. This, some people argue, is too much. The surrogate, they argue, should be paid in a manner that reflects her work of actually carrying the fetus in order to reflect the fact that she has temporarily limited her reproductive and lifestyle liberties in favour of the intended parents' interests. Balancing this interest with the intended parents' interest in ensuring that the surrogate hands the delivered baby to them in accordance with the contract is therefore still an open question about which there is much debate. As already mentioned, currently the ART rules 2010 heavily favour the intended parents' interests. A surrogate runs several expenses in the process of surrogacy. Most of these are medical expenses related to the pregnancy during the IVF process and pregnancy. However, there are other non-medical expenses that the surrogate may encounter during the surrogacy process. With regard to medical expenses, the overwhelming majority of arrangements provide that the intended parents must cover these costs. It would only be in the rarest of rare cases where a surrogate may undertake these expenses personally. However, in some cases, the surrogate may also have medical expenses caused by the pregnancy which continue after the delivering of the baby. The question therefore arises, for how long do the intended parents need to cover the surrogate's medical expenses post-delivery? What if, for example, a surrogate needs to have a hysterectomy after the pregnancy? Here, the ART Bill 2010 provides that the intended parents must ensure the surrogate is appropriately insured. However, appropriately insured is a vague term. Would it also cover life insurance or chronic lifelong issues? There are also several non-medical expenses that a surrogate has to cover during pregnancy. One major one in India specifically is housing. The Indian surrogate generally comes from a poor or lower middle class background and is in dire need of money. The main reason for the overwhelming participation coming from the poorer classes is probably largely rooted in the social stigma that still surrounds surrogacy. It is this very social conservatism that leads many surrogates to seek alternative housing arrangements during the pendency of the surrogacy. Housing is predominantly provided by the ART clinics. Both the ART clinics and the intended parents benefit from such an arrangement as they are given complete access to the surrogate. This expenditure is necessitated by the surrogacy arrangement. It must therefore be provided at the intended parents' expense. As currently framed, the contract in the bill could leave the surrogate covering the charges imposed by the ART clinic for housing and food during her pregnancy. This reinforces the weaker position of the surrogate and her inferiority in the negotiation process and the subsequent tangible benefits received. Imagine, for example, if the surrogate paid for all of her own board and lodging during the pregnancy, expecting to receive 75% of the value of the contract when the baby is born. If, after 9 months of pregnancy and the associated loss of liberty and bills for accommodation and food, all borne by the surrogate, a stillborn child is born, what financial remuneration will the surrogate receive? Answers to such questions are currently legally unavailable. The bill and the rules should provide for the provision of independent psychological counselling services and independent legal services for the surrogate at the cost of the intended parents. The emotional and mental strain of the surrogacy experience is no small matter. First, the surrogate worries about whether she will become pregnant or not. Strain is added by the fact that most surrogates stay in in-clinic provided housing where they are separated from their family. Moreover, the counsellors at the clinics have a conflict of interest as their employer is the clinic who was funded by the intended parents, not the surrogate. Having the intended parents cover the cost of independent legal advice and psychological counselling for the surrogate is not a revolutionary idea. The State of Israel requires intended parents to pay for the surrogate's legal fees and also requires the intended parents to pay for the surrogate to receive psychological counselling throughout the process until 6 months after delivery. Both of these requirements are included in the surrogacy agreements. Such reforms should be debated and considered widely and openly within India, and a greater attention is owed to the position of the surrogate to ensure the law is both sympathetic to the lived reality of many surrogate women and ethically and morally accountable. This is perhaps especially important given India's popular location for surrogacy services for intended parents coming from abroad and fueling demand for the industry, partly because of the cheaper costs and lack of substantive regulation. This module has considered the differing reasons people have for choosing to have a child via surrogacy, how IVF is performed, the multiple forms of surrogacy, the economic incentives to become a surrogate, and the medical processes during a surrogacy and the surrounding issues of access to reliable, full information, the need for informed consent, the expenses of a surrogate that are not comprehensively considered or covered by the law, the vulnerability of the surrogate within the current ART bill and rules. Surrogacy is a practice that is gaining momentum in India and requires significant public debate. The issues involved are sprawling across legal, medical, social, and psychological fields. Currently, inadequate attention has been given to the surrogate's rights, needs, and wants. The ART bill is a good start, but a lot more work remains if the protection of women's rights, especially the most vulnerable women's rights, are to be fulfilled. This module is now complete.